What we find is this is one of the most powerful lawsuits that can be brought. It usually gets resolved very quickly because the seller faces a parade of horribles if they don't deliver. They'll have to pay their attorney's fees. They'll have to pay the buyer's attorney's fees. They can't sell. They can't refinance. The property they might have to sell 2 years from now at today's price. It's horrible for a seller. So if you're a buyer, you're in the driver's seat.
Hi, this is Kris German. Welcome back to the Apartment Dealer Show. With me today, we have Mr. Spierer Spierer. Now, if you've been a subscriber of our channel for any time, you've seen interviews I've done in the past with Steve that helps us break down, dive into what are all the things we need to know, the logistics of litigation, real estate law, as landlords. What do we need to be aware of? What are the trips and traps that individuals, investors are falling into that we can avoid if we have the knowledge of somebody like Spierer Spierer. Now, Steve has been a practicing real estate attorney now for several decades, and even more impressively owns a few thousand multifamily rental units, aside of industrial, office space, retail, and so forth. So he brings that depth of knowledge of being an investor to the table as well, having ran syndications and all the rest. So that's why we invite Steve to be on the show and why we invite Steve to be a part of our Apartment Owners Educational Luncheon. We believe he's just the best at what he does, and he has the information, the right information, to inform landlords like yourself. Steve and I today are going to dig into a whole host of topics that I know you'll find informative. And so with that, help me welcome to the show, Mr. Spierer Spierer. So Steve, welcome back to the Apartment Dealer Show.
Glad to be here. Good to see you.
And we're in the middle of interesting times. Of course, interest rates have more than doubled when it comes to commercial real estate. Different things are in flux when it comes to the economy. Just today, as the recording of this video, yet a second bank closure was announced. And what do you make of that? What do you make of these current issues that we've seen in the banking system?
It makes perfect sense. When interest rates were very low, the banks, when they have deposits, they have big deposits from their bank customers. They want to get money for it, so they buy bonds. And what Silicon Valley Bank did, I don't know about the one who went bankrupt this morning, March 13th, but Silicon Valley Bank from last week went out and they bought long-term bonds because they could get a higher interest rate. Because when you lock up your bonds long-term, you usually get a higher interest rate as long as interest rates aren't inverted. And so they got a higher interest rate. And then when the Fed raised interest rates severely and suddenly, that caused the value of the long-term bonds to drop. So the bonds were worth less, and there's a big loss. And that ordinarily wouldn't have hurt the bank because Silicon Valley Bank would have just waited and the bond would have continued to pay. And at the end, the bond would have come due and they would have gotten their money and they wouldn't have lost any money, but they wouldn't have made any money. They couldn't trade because the bond was worth less. But instead, their bank customers started making withdrawals and they didn't have enough cash on hand. So they had to sell those long-term bonds that they had bought for a lot, for less, and they lost millions or hundreds of millions or billions, we don't know. It's a bunch of money. They lost money enough that they fell below the standards, the federal standards the Department of Treasury has set that tell the banks how much they have to have in cash. And that's when they got taken over. The bottom line is this should not create a run on the banks, but the fact that there's another bank in New York this morning, the fact that there'll probably be a few more, isn't good. And the question is, what's that going to do to the Fed? This Wednesday, I think it is, March 15, is going to decide to increase interest rates. I think they were going to go up a half a point. I think now they'll go up a quarter point. They have to do something because inflation is far from under control. If what you have are property owners who are over-leveraged, who all of a sudden find themselves faced with a triple threat, a perfect storm, where their monthly payment has gone up materially and their monthly income is down because tenants are not paying rent. And let's say the COVID moratorium is continuing, or the economy takes a dip and they have vacancies, or they have to make rent concessions or even lower rents, and they now have a cash flow problem. They can't pay the payments. That's where you're going to start seeing the beginning of a cascade effect. Moreover, people whose loans are coming due, who have to refinance, if the value of their property is down and it won't appraise well enough, and they were too highly leveraged, and interest rates are up, which makes it even worse because they're too highly leveraged, they can find themselves unable to refinance, and they might have to install money.
Bring cash to the table just to close the loan.
To the table to refinance, or they might have to sell. And if they have to sell, it's going to be a panic sale. It's going to be a sudden sale. So we could, from the perspective of the apartment dealer, Kris German, and the apartment investor, Steven Spierer, we could see some opportunities to purchase properties in a distressed condition. I would say that if someone does not have to sell, I'm not sure this upcoming time is a good time to sell, unless you're selling to trade up and do something to expand your footprint.
Unless you have a plan, but not, sell for the sake of selling. Sure.
Yep.
So I'm curious then, to start us off, when markets are in fluctuation, whether they're trending downwards or trending upwards, again, here recently, interest rates are putting a lot of pressure on the market. Do buyers and sellers naturally get more litigious? Do all of a sudden, do you start getting more phone calls of people trying to back out of deals and they're not performing because a market's in flux? Does it make any difference for you?
Unfortunately, we get calls all the time. In a market where the prices are going up, we find litigation by buyers who are in a contract to buy a property, and the seller says, "Oh, I think I sold for too little. I have seller's remorse. I want more money for my property." So we're representing buyers suing sellers for specific performance to force a seller to sell at what they said they'd sell for. In a market where things are falling, we have sellers wanting to keep the deposit of the buyer who removed contingencies or is otherwise obligated to release money because the buyer isn't going to pay, and we have issues over that. So we see lawsuits in all of those. But the lawsuits are really pretty rare, and they usually happen when people have made miscalculations because they didn't know what they were doing. They tried to save money. They got a discount broker who's charging less, or they tried to do it themselves, and they somehow made mistakes. So they end up being sellers or buyers with regret because they didn't pick the right realtor to represent them, and they got themselves in trouble because, of course, it's not what they do for a living. They're doing something else for a living, and they own an apartment building as an investment, but they're not experts in how to buy or sell, or sometimes not even how to manage it.
And when it comes to performance, so let's say the other party isn't performing, whether it's the buyer or the seller, and you mentioned, give them a notice to perform. Now they're given the notice to perform, gives them 3 days typically to whatever that may be, close the escrow, remove a specific contingency. Let's say that notice to perform is issued, comes in, the 3 days come and go, the other party does not perform. So now you move to cancel the escrow, but the other party is not responding to any emails. They're not responding to escrow. They just won't sign the paperwork to close. What's the first step of the party that's pressing the other party to perform? What's the first step?
So in the scenario that you outlined, we're going to separate it if you're the buyer or the seller, because they're two very different things. If you're the buyer and the seller is not performing, and you've given the notice and they're not performing and they're not closing, then the best thing to do is fire a warning shot into their leg. You file a lawsuit for specific performance. You record a lis pendens. You say, you can't sell to anyone else. You can't refinance. You are frozen in position, and I'm seeking a court order ordering you to specifically perform the terms of the contract and sell me the property. What we find is this is one of the most powerful lawsuits that can be brought. It usually gets resolved very quickly because the seller faces a parade of horribles if they don't deliver. They'll have to pay their attorney's fees. They'll have to pay the buyer's attorney's fees. They can't sell. They can't refinance. The property they might have to sell 2 years from now at today's price. It's horrible for a seller. So if you're a buyer, you're in the driver's seat. If you're the seller and the buyer isn't performing and they're languishing, then if the documents have been done right, if you've got all your ducks in a row, then you say to the buyer, it's time for you, how do I put this, Kris, so it's delicate? It's time for you to sing or get off the stage.
Yeah.
It's time for you to get in or get out, to dial or get out of the phone booth, either close this escrow and buy it or get out of my way and I'll sell it to someone else. And if we do the paperwork correctly and send the notices correctly and all the demands are done correctly, which a good realtor is going to be able to do, then the next result is that you cancel, you send the notice of cancellation, and then the seller goes ahead and resells to buyer number 2. Now, kids, don't try this at home, because what you don't want to do is accidentally engage yourself in 2 binding contracts, one to sell to buyer 1 and one to sell to buyer number 2, because you'll get to move in life from a position where you said, I've never been sued before, to saying, well, now I've been sued twice in 1 week over the same property. And we see that all the time when it's mismanaged. But if it's managed correctly, the seller can go on and sell to buyer number 2 and then just have a fight with buyer number 1 over the earnest money deposit.
Let's put agents on the hot seat for a minute here, which I'm one. I'm a realtor. But what is the most common reason you see landlords, real estate investors, suing real estate agents? I'd be curious.
It's all boils down to lack of communication, where you have realtors who, when they meet with you, they're going like this and looking at their watch all the time and saying, I got to go, or they aren't returning calls, or they're lazy about how they do things. That usually translates into a loss of confidence in the realtor. And when you have those conditions, the realtor is more likely to get sued when anything goes wrong. And we see this lack of communication, not just in not returning calls, but when you ask your realtor a question and the realtor says, well, I don't give advice on that subject. There are ways that excellent realtors can either be the source of the information. In other words, it's something within the purview of the realtor is going to give the answer and give the advice, or the realtor can be the source of the information. I don't know the answer to that, but I'll get you a structural engineer who will be able to figure that out, or a soils engineer, or a licensed architect, or a licensed contractor, or a licensed electrician, or a certified property manager, or whatever it would be. The realtor is the source of the information. The other thing is where realtors sometimes give answers that they don't know the answer to, but they give the answer anyway because they want the deal to come together. Because
or they don't want to look ignorant to the whatever's being asked of them. Yeah,
exactly. They're afraid to say, I don't know. And so they say things to reassure their clients. They say to the buyer, don't worry about those cracks. Those cracks are just settlement cracks. Those are minor cracks in the walls. My house has cracks. Don't worry about the cracks. And then it turns out that the foundation was falling apart and the building, the apartment building needs $400,000 worth of structural work to make it solid again, or soils engineering, put it on caissons or whatever the problem is, where the realtor has gone beyond the scope of what they know to reassure someone so the escrow will close.
You know, I'll tell you a story here. So I met a buyer who says, hey, you were involved in this transaction on another building over here. He wanted to buy that building 2 deals ago. So now this is the second time the building's being put on the market, like in a 5-year span or something. But he says, when I wrote the offer on that property, the agent who was representing the seller sat on the offer, never told the seller that this offer had come in. But this buyer actually had mailed the offer to the seller. So the seller had it in hand. So after the agent was done presenting all the offers, the seller says, well, what about this one? And lo and behold, they knew about this other offer that hadn't been disclosed to them. I've also heard matter of fact, 2 weeks ago, I had a buyer call me interested in one of my listings. He says, hey, did you know about this deal over here in such and such street? I actually contacted the listing agent and told him I'm interested. I'd like to write an offer. Agent never got back to me and ends up the building sells. So what are buyers and sellers to do in this situation? I know they're kind of, these two issues are two different issues. But so we'll start with the seller then. How are you one to protect yourself to know that all the offers that are coming in, your agent is actually sharing with you and not his favorite client's offer or an offer from his buyer so he or she can earn all the commission? How do you prevent something like that? And if it comes to light that that's happened and you would do business otherwise, choose a different offer or what have you, what's the seller to do?
This all comes down to integrity. And if you're dealing with someone with a lack of integrity, then they have a lack of integrity. It's not okay to say, well, they're dishonest, but they're on my side. There's no such thing. Someone has a lack of integrity, they have a lack of integrity. And the most important thing for any client of a realtor, of a lawyer, of a doctor, of a car mechanic to do is to figure out whether the person that they're dealing with has integrity. And the best way to do that is to ask questions. So if you get a great deal of glad handing from your professional who's just reassuring and I'll handle everything, and anyone who says, trust me, I don't want to explain it, but just trust me, I know how these things work, those are all red flags. To me, if you know something, you can say it and you can write it. And if you can't say it and you can't write it, then you don't know it. And so when you're a seller and you ask your realtor, what's your policy with respect to presenting offers? And the realtor might say, what do you mean? Well, if you get a call from a realtor who says, I'm going to write an offer, what's your policy? Do you tell me that? Do you tell me that that's what they're doing? And if not, why not? And if the realtor says, well, I don't want to bother you with every fool that calls me and says they're going to write an offer, the seller should say, no, it's no bother. I want to know everything that happens with respect to my property. And I mean everything. If somebody calls, if somebody writes, if somebody comes by, if somebody expresses an interest, if someone says they're going to do something, I'd like to know. I'd like to be regularly informed as to all of those possibilities. And I'd like you to do it with me in an email so I've got a track record so I know I've been told everything. How do you feel about that? And if the realtor says that's too much trouble, or if the realtor says, no, that's not how I do things, I'd ask more questions. So how do you do things? How do you react if a realtor says to you, I think I want to make an offer on this property, what do you do with that? And see what they say. I write it in my file. Well, good. Send it to me. I don't do anything. I wait for the offer. That's not okay. You've got the wrong realtor at that point, because we see this all the time. A listing agent who lacks integrity has a listing and they want to double end it. So they've got a buyer that they'd like to sell it to so they can get a double commission. They get the selling broker's commission and the buying broker's commission. So instead, there's someone else, say Kris, who has another buyer who wants to come in and make an offer, and they're not so favorable on that because they're not going to get the extra money.
And from the buyer's perspective, you've called the listing agent because you've heard around town, hey, you want to write your offer with the listing agent, and the listing agent just doesn't respond. They say, yeah, I'll get back to you, and then just is it as simple as, well, just move on, find an agent to write that offer for you so that you get an offer submitted? What do we tell our buyers?
It's a very tough one because here's the ugly one. Here's the ugly alternative. The ugly alternative is you explain to your buyer that I'm not getting return calls from the seller's agent and I don't think your offer is going to get a fair shake. And the buyer goes directly to the seller and says, I want you to know I've just submitted my offer through my realtor, and I want to make sure you see it, so I'm sending you a copy anyway. Well, this is a problem because it's going to make the listing realtor angry. The listing realtor will say, gee, this buyer seems like a wild man. You probably don't want to sell your building to them, so it can backfire. It can scare the seller and backfire in that way. And it's going to make everybody mad. Your other alternative is submit the offer and hope for the best. There's not really much more you can do. What that realtor for the buyer can do is they can say to the seller's agent, if I don't get this property, I'd like to get a copy of your seller's rejection of my offer. And if I get that, I'll be happy. And if not, and I don't get this property, then after the close of escrow, I'm going to contact the seller and find out if they saw my offer and what was said about it. Again, this is ugly. It's hostile. It will make everybody mad. It may not get you the building because it may backfire. because it makes people mad.
Now, on my show, our educational events, we spent a good amount of time talking about substantial improvements because it is one of the few ways, if not the number one way, to still vacate units under statewide rent control. So to that point, as landlords are vacating units and they get ready to do these substantial improvements, if they hire tradesmen that are not licensed, so they're not carrying insurance, and these substantial improvements typically consist of redoing the plumbing, redoing the electrical. So now you have unlicensed tradesmen with no insurance, say, updating all the electrical, running new Romex, updating the sub panels and so forth. And let's just take it to the extreme. One of them gets electrocuted and kills himself on the property. Okay. Or they leave exposed wires and somebody comes along and grabs a live wire and somebody gets hurt on the property. Now what?
So this is during the time when the seller still owns the property?
Yeah, they own well, we're just saying, not even a seller buyer. I'm a landlord and I'm doing substantial improvements on my property.
Right. The first thing is it was an unforced error. It was an avoidable tragedy. It was something that didn't need to happen. And what I would say is if you're going to use a handyman to plane a door because it's sticking on the carpet or it's sticking in the doorway, great. If you're using an unlicensed handyman to do a little painting here or there, a touch-up painting, all right, I'm going to look at that and say there's not all that much that's going to go wrong. When you have someone redoing electrical work, you need a licensed electrician. And that's expensive, but it's not nearly as expensive as what happens when what you just described, Kris, happens and there are lawsuits, there are injuries, there are deaths. It's a shortcut, and the people who are doing things that way are not running their apartment business the way they should. And the reason is this: people who are in business generally take their business seriously. They say, I'm running my business, I want to run it well, I'm going to do it to the best of my ability. Sometimes people who invest in an apartment building, they buy a duplex or a fourplex, and they're not really in the business, they're in some other business, but now they want to invest their money and they buy it. Instead of looking at it as another business that they're in, they look at it as, well, it's just an investment. And then they look at it and say, well, the least money I spend, the better off I'll be. And of course, that's wrong. And so then they're not very good landlords. And many times over a long period of time, over decades, they make money anyway. And then they congratulate themselves on how smart they were. But those are exactly the people who frequently get into trouble and have the scenarios that you're describing where something goes wrong. So my advice would be, if someone is going to invest in real estate, whether it's a duplex or a 400-unit building, you're in that business and you need to do it correctly. So you need to get the professionals to help you do it correctly. You need to get the tradesmen to help you do it correctly and do it correctly. Be a good landlord and deliver a habitable space that's safe where people don't get electrocuted. And if you don't, you do that at your own peril. We see more and more where insurance companies deny coverage for a variety of reasons. If you are driving your car and you have car insurance and you dent someone's fender or you have a collision and it costs $10 or $20 or $30,000, you're in good hands with Allstate or State Farm or Farmers, and you'll be fine and you'll be happy and you'll say, gee, they did the job right. But if you drive your car into the center of a school bus and do serious injury to a whole bunch of children, the first thing your insurance company will do is try to figure out all the ways they can cancel your insurance. It's just the reality of the insurance business. So when you have an apartment and you electrocute people because you had unlicensed contractors, you're going to tender it to your insurance when you get sued for millions of dollars. And your insurance company's first response is going to be to figure out whether there's some basis on which they can cancel your insurance. And lots of times, the same people who used an unlicensed contractor to do electrical work didn't vet their insurance properly, may not have coverage properly, and there may be a way to rescind the insurance contract, give you back your premium for that year, and tell you you're on your own. So if you're going to do something, do it right. Do it to the best of your ability. If you think you just own 2 units, I'm not really in the apartment business, then you better sell them and put your money somewhere else, because if you own units, You have a responsibility under the law to do it correctly. And you have just as important, you have a responsibility to yourself to do it correctly, to protect your investment by doing it correctly. Licensed electrician is the only one who should do electrical work. I'm going to say the same thing for plumbing and roofing and a whole bunch of other things.
Now, over the last, I say, month, all of a sudden I got about 4 different calls, various landlords calling me if I knew someone that does mold remediation. And so I thought I'd ask you the mold question. So mold shows up in a unit. Oftentimes landlords are not doing annual inspections, and so they have no clue. The tenant hasn't raised their hand and said, hey, I noticed there's this black stuff on the wall or what have you. The landlord's responsibility here. The tenant didn't bring up an issue until it's too late. And yet you weren't doing annual inspections, but there is mold. What's your liability here if the tenant were to get sick, say?
All right, so let's divide it into 2 pieces. First of all, every landlord should do an annual inspection at the very least. Sometimes in some properties, in some areas, you should do it twice a year, and I've seen some do it 4 times a year. So, but at least once a year, you go through and you take photographs and you take notes. And this isn't just you walk around and chat with the tenant. This is you really inspect, and you turn on and off every water faucet, you flush every toilet, you open and close every door and every window, you look in every cabinet, you observe anything you can observe and figure out whether there are any signs of any trouble at all. So that's an inspection. And you fix anything that's broken. You don't wait to be asked. When you see it, if it's a problem, you fix it, because you're on notice of it now. So now you did the annual inspection, and now it's been 10 months and you haven't been in, and that's fine. And the tenant hasn't said anything to you. You don't have responsibility for what you don't know. You have a duty to know certain things. You have a law that says you are responsible for what you knew or should have known. So if you're not doing annual inspections, you should have known. But if you did, and then you did, there's nothing to see, and then something happens afterwards, don't worry about that. But once the tenant brings it to your attention, you have to do 2 things right away. 1, you have to react right away. There's no delay. Someone calls you on Monday and says, I got a problem. You react on Monday. And if the call comes in at 5 o'clock on Monday, okay, react on Tuesday. But you don't say, yeah, I heard about it a few weeks ago and I've been busy, or I was traveling, or I have whatever problem I had, I was sick, and so I think it doesn't matter. You have a legal responsibility to react right away. So that's the first thing, is react right away. The second thing is you have to react capably, competently, non-negligently. So if someone says, I think I've got mold or mildew, or I find my kids are getting sick, I'm getting sick, I think there's a problem here, you need to immediately order professional inspections, in this case mold, and get somebody out there to test things. And if the place is not safe, you need to tell the tenant and tell them to get out and put them in a hotel, and you continue to collect the rent while you pay for the hotel, or you abate the rent while they pay for the hotel. You make an agreement with the tenant, you write it down, everybody makes an agreement and knows what it is, and then you do the abatement. And you don't do it by sending in someone with a rag and a bottle of bleach. You send in a mold remediation team who's going to actually do this correctly and give you a mold clearance and say it's all clear. And landlords at this moment usually say to me, well, it's because they're taking showers without the fan on, and it's because they're open the windows, and it's a tenant problem, and they have cockroaches because they leave food all over. Well, you better be able to prove that. You better have pictures. You better be able to show that. And there are fans you could put in to your apartment units that when they turn on the light, the fan is on. And if you don't have that, that's a problem. You also have some fans that'll stay on 24 hours a day. That's a good idea too in many situations. But what you don't want is a situation where the tenant behavior ends up generating liability for you.
Now let's talk property lines. Oftentimes, buyer and seller, everyone's assuming that where the block walls are, that's our property lines. But let's say that comes not to be the case. I recently dealt with this, and I've seen it a few times prior, where come to find out the chain link fence, the block wall, what have you, was either too far on the neighboring property or was too far in, and you were giving up some land. Is there some sort of law that says, well, if the wall's been up for this long, you either forfeit that land to the adjoining owner, or now you can take possession of that land because the other owner has not claimed the land that's on your side, closest to your parcel? How do you deal with property lines?
All right, so let's start with, we got basically two different stories. The first one is, where's my property line? And so the buyer who's buying the property says to the realtor, is that fence over there? Is that where the property line is? There is only one answer to that question. And the answer is, I don't know. But since you've asked, let's get a survey. Let's have a survey of this property so you know where your property line is. That's the only possible answer. Because sometimes what you get is, again, that realtor who wants to reassure their client says, oh yeah, that's probably right where it is. It's probably right there. Nobody has any idea. We have cities, entire cities, where down the block, this property is encroaching on this one. And that property that's being encroached on by the neighbor to the north is encroaching on the neighbor to the south, all the way down the block. Every property is being encroached upon and is encroaching. And if you don't have a survey, you don't know where the property line is. So if anybody cares where the property line is, the answer is a survey. There is no other answer, no other answer, no other answer. Now, once someone has trespassed, what you're discussing, Kris, leads us to a discussion of prescriptive easements, adverse possession, and the doctrine of agreed boundaries. These are three completely different, separate laws that I won't presume to explain fully today because they're full law school courses and they are the subject of continuing education of real estate attorneys. And it's a very narrow band of lawyers who understand those rules. And there are plenty of misunderstandings about it. But what it boils down to is that these rules act as a reverse statute of limitations. If someone trespasses on my property for long enough, that person gets a right to trespass on my property. It's counterintuitive. You're trespassing on my property. Why would you get a right? Well, this reverse statute of limitations says that if they trespass on me and I don't do something about it, and there are things to do, if I don't do the proper things about it, I've waived my rights. So that's the basis for this. So if you know of someone who's trespassing on your property, you need to get legal advice and figure out exactly what the trespass is, what you want to do about it, what you can do about it. It would literally take an hour for me to explain this.
Now, I want to discuss disclosures here just briefly, but particularly with to one topic here, rent control. So, of course, we have statewide rent control. We've had statewide rent control now since 2019 here in California. You would think every landlord knows by now, but you'd be surprised how many landlords to this day we're discussing something and I'll tell them, well, you know, under rent control, you can do this or not do this. And they'll tell me, oh, no, my property's not in LA City. I'm not under rent control, because they think rent control is still in LA City, still to this day. And I guess in their defense, it's not like a mass mailer went out to all apartment owners saying, hey, there's rent control, not to the best of my knowledge anyhow. But nonetheless, every city in California has rent control. And on top of it now, even some cities have dreamed up their own versions of rent control. They're extra layers that would layer on top of statewide rent control. So with regards to disclosure, is it a buyer's responsibility to know that in the city they're purchasing, there may be a direct RSO there, plus we have statewide rent control? Or does the seller have responsibility to notate that somewhere within the disclosures?
So RSO, Rent Stabilization Ordinance, we have one for the state, as you say. A bunch of cities have them. And no, ignorance of the law is no excuse. The buyer has a responsibility to know all the laws. And a seller doesn't have any responsibility to tell the buyer about laws. The seller has a responsibility to tell the buyer about the property, to tell all the facts, to tell all material defects in the subject property. And I would say a seller is wise. It's not the law, because the law is tell all material defects in the subject property. I think it's wise for a seller to tell all, not just material facts, not just defects. that might remotely be of interest to the buyer, not just in the subject property. And if a seller tells all facts that might remotely be of interest to the buyer, the seller's also going to say a sentence that says the buyer should investigate what rent control ordinances, rent stabilization ordinances may apply to this property. You can put a sentence in like that, but no, the seller doesn't have a responsibility to do that. The buyer is the one who, with the assistance of their realtor, should figure out what rent control applies to them and why it's going to matter and why it won't and how they can deal with it and respond to it. But no, a seller doesn't have a responsibility to disclose laws. They have a responsibility to disclose facts.
Well, Steve, you are a wealth of knowledge, and that's why we look forward to you being at our next apartment owners educational luncheon. Of course, registrations are nearly almost gone here leading into the event. Is always the case. I know that you're one of the highly anticipated speakers that's now been involved since the beginning, so we thank you again. Now, Steve, before I let you go, I have one more question that I've essentially been asking the various speakers as we have these interviews leading up to the event, and it's this. From your perspective, real estate law, what's the number one mistake landlords, real estate investors make when it comes to owning and managing investment real estate?
They go in without a plan. They think that they're just doing something like when they invest in the Ford Motor Car Company on the stock exchange. They think they're just buying stock and they're buying something and they'll just buy it and own it and it'll just be fine. And you can do that because there are all sorts of protections in the stock market so that when you buy a share of the Ford Motor Car Company, you actually own it. And there are rules and regulations for how things are run and how things are represented. They're called blue sky laws that prevent you from buying a big hunk of blue sky. There's no such protection in real estate. In real estate, you need a plan. You need to know, how am I going to manage this property? What is the financing going to look like? What am I going to do for a backup plan? How much capital reserve do I need to have in order to properly maintain the property? What am I going to do? Is there rent control? What do I have to do with it? All of the things someone is undertaking a project when they're going to own real estate. Now, I think it's a really good idea because it has so many advantages over the stock market. Huge fortunes have been made in the stock market and in real estate. But in real estate, I think it's a huge advantage for tax, for leverage, for financing, for the fact that in stock, when you buy a stock, you buy it with your money. But when you buy real estate, we live in a world where total strangers will buy that real estate for you. And those
Tenants.
They're called tenants. And nothing beats this. It's a formula for building long-term wealth, but it comes with responsibilities. And so not having a plan, that's the thing that gets people. They just figure, yeah, I'll just buy it and set it and forget it. Like, I bought my Ford stock and I didn't think about it. And 30 years later, it was worth more. It's not how it works with real estate. It requires attention and a plan.
Well, and that's why we hold these gatherings, to assist people if they have no plan, to give them some things to think about what should be in their plan. And if they have an existing plan, maybe that plan doesn't work anymore because owning multifamily properties has only gotten more difficult, not easier as time has gone on. And that's why we bring the landlords together. And we look forward to it, Steve, to you being there with us to help us educate them and to discuss what are the pressing topics today when it comes to apartment ownership. Mr. Spierer, thank you again for your time, and we will see you soon.
I look forward to it. Practice safe sales.
Well, I know you found today's show informative. These are some of those trips and traps that I mentioned that you want to be aware of as a real estate investor, and how to keep yourself out of hot water, but more importantly, how to move on to massive profits with no headaches, right? We don't need stress and headaches along the way, and no need to have self-inflicted injury because we try to do things, manage our properties incorrectly, do things the wrong way. Now, for those of you that own in our area of service, the seats are nearly gone. You'll want to be there coming up here on March 28th at our Apartment Owners Educational Luncheon. Aside of Steven Spierer, we have Mr. Gil Figueroa, who will be discussing all things commercial lending, and what you need to be aware of on your existing commercial loans that could be a ticking time bomb. We'll have with us Mr. Dave Barrett of Cost Segregation Services to discuss what is now becoming one of the most popular tax deductions when it comes to owning multifamily properties. We'll also have with us Mr. Warren Thomas to discuss all things DSTs, what you need to know, how do they work, is it a good alternative to multifamily properties, or just to put some cash that you may be sitting on if you don't like the turmoil that you currently see in the marketplace. And we'll have with us Mr. Mike Brennan, eviction attorney extraordinaire. If you own here locally, you know that legislation over the last couple of years has changed about every quarter. And so Mike's going to bring us up to speed. Well, where do things stand in LA County versus LA City versus unincorporated Los Angeles County versus incorporated Los Angeles County? Not to mention the individual city that you may own in. Maybe unbeknownst to you, they have their own rent control ordinance, as many cities do now. So Mike is going to bring clarity, shed light on what it is you and I need to know as landlords, and make us aware of, maybe we don't know going into the event, but make us aware of the most current legislation, and then what's pending or what is on the politicians' minds that we may see here in the near future, and what can we do today in order to put ourselves in a good position if and when these new laws come into effect. Nonetheless, this event is multifaceted in terms of all the areas that need to be addressed when it comes to owning multifamily properties. Be sure to register now. Once the seats are gone, they're gone. We keep the event small and intimate so that you, as an attendee, have an opportunity to ask your personal questions to the speaker panel. So this is an event not to be missed. If you have not already, be sure to subscribe to our channel. Give the video a like. That helps us get this content into the hands of more landlords. And turn on alerts by ringing that bell below. That will make you aware of when we release our newest content. And we have a lot of great content scheduled out for you here in the coming months. And what we look to do as we share this content is to empower you, the landlords, so that you can pivot to profits and that you can build your financial legacy in multifamily properties. Kris German from the Apartment Dealer wishing you positive cash flow, tenants who behave, and much protection from Uncle Sam. Till next time.